hard to imagine today, but when the United States was formed, most areas policed themselves.
The idea that a police officer, the guy walking up and down the beat with the stick, who really is going to sort of maintain order, it's a new idea in the United States. The police departments don't start in the United States for the most part until the middle of the 19th century in any real way.
Not only were departments kind of new, but local police didn't care much about the U.S. Constitution. Look at this. Congress shall make no law. Back then, the courts said the Bill of Rights only applied to the federal government, not the states, which to this day are responsible for most laws regarding crime. Now, it wasn't legal to torture anyone, but check this out. In 1931, a presidential committee called the Wickersham Commission said beatings had become a regular part of police interrogations.
They had boxes and boxes of documents, many of them from police themselves, saying, yeah, we've seen our colleagues do this, or even I've done this. And that caused a tremendous national outrage.
The question is, what else should the Constitution have to say about what was going on in the interrogation room?
Look at this. Dragnet was one of the most popular television series of the 1950s, just a few years before Miranda was arrested. Now, they're about to make the arrest.
All right, lady, relax, will you?
Oh, look at him, the big stoop.
Wait for
I told him
it.
it couldn't last forever. I told him a week ago, let's get out. No, he had to try once more, the big dumb stoop.
All right, lady, let's go.
We'll take him, Angus.
Get him.
And,
Better get that shirt fixed, huh? Come on, lady.
nothing. There was no rule that said the police had to inform someone under arrest of their rights before interrogating them, so they didn't.
The ideal place for an interview in most cases is going to be the police station interview room. It has many advantages. Not only is it private, but you are in psychological control of the environment.
This is from a police training DVD on interrogation. The Read technique is a video update of training manuals that haven't changed much since they first came out in the 1940s. To the police, a trip to the interrogation room should come only when they think they can make a case against a citizen.
You're dealing with a very special kind of contact between the police and a citizen. The aim of an interrogator is to get what will amount to a confession of the crime.
There's a presumption of innocence before the trial, and that starts all over again when the trial begins. But in between, the police gather evidence they hope will lead to an arrest of someone they think is guilty.
Interrogation is a process that is specifically designed to develop an admission of guilt.
What the training manuals advised is that what the police should do is to bring a suspect into the station, tell the suspect, we've got the goods on you. We can prove that you did it. We have your fingerprints, we have eyewitnesses, we've got everything. Sometimes they do, but they are authorized to and they're told to lie.
Interrogation rooms can be the ultimate home court advantage. And if you don't know your rights, chances are you're in deep trouble, whether you did anything or not.
And there's no lawyer there to advise you, to tell you that you should shut your mouth. The best advice that a criminal suspect can receive, even one who's innocent, is shut up, talk to your lawyer, have your lawyer talk to the police. Silence is a vacuum that humans don't like.
At the time Miranda gave up his right to be silent and confessed, it was hard to tell if the police had crossed the line in the interrogation room, and the courts had to get inside the mind of each suspect to determine if the confession was given voluntarily.
So the question was this confession given voluntarily, or was the will of the defendant overborne by the police? Did they somehow force this out of him?
But how can you tell? There's Ernesto Miranda, who was never told he was under arrest. The police told him he was identified in a lineup when he really wasn't. He probably didn't know he had a right to remain silent, and he didn't have a lawyer until he got to trial, which was too late, because the one piece of evidence the prosecution had in court was the confession he wrote in the interrogation room. So was Miranda's confession given voluntarily in a situation where the police just had some leverage? Or was the situation so lopsided the confession was compelled and a violation of his Fifth Amendment rights? At the trial, Miranda's lawyer argued that Miranda had the right to have an attorney present in the interrogation room, and that he should have been told he had the right to remain silent. But that wasn't the law, so the trial judge overruled him and allowed Miranda's confession to be admitted as evidence. Ernesto Miranda was convicted of rape and abduction and sentenced to 20 to 30 years in prison. His appeal, based on his confession, went all the way to the Supreme Court.